and most imposing of public buildings in Washington is the home of the highest judicial authority in the land.
The highest judicial authority in the land.
The Supreme Court of the United States.
Established by the Constitution as one of the three branches of the federal government, the Supreme Court enjoys equal prestige with Congress and the presidency, and exercises tremendous influence in the affairs of the nation. Though the size of the court has changed from time to time, today it consists of the Chief Justice of the United States and 8 associate justices. The highest judicial authority in the land.
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 All right, guys, welcome back to Article 3 Articulations. And today, this educational experience is going to be called Citizenship 1. And I am excited about today because today we're going to talk about one of the most famous cases, especially in the law community, but really one of the most famous cases ever. And because this case it was right after the Civil War, and it dealt directly with the 13th, 14th, and 15th Amendments. In particular, the 14th, though, and that's where all the discussion comes from. And this is it's a big case. It's confusing. You got to go through a lot. There's a lot of background. There's some law history, But I'm excited because I'm going to break it down for you today, and we're going to see what it's really all about. So first, let's go over here to Citizenship 1 intro. First, though, since we're going to be talking about the Supreme Court so much in this show, what I wanted to do before we start every episode is kind of just touch back on the Supreme Court a little bit. So what I did is I found what's called the Supreme Court Code of Conduct. And this is, funny enough, they didn't even publish this until November 13th, 2023. And before this time, there was not a Supreme Court Code of Conduct. So in 2023, they finally decided, maybe we should write some rules down for ourselves. So we're going to go over that, and we're going to see in all of these old cases if they had any integrity, and we're going to come to find out in the case today that maybe they didn't. But before we do that, let's start with the preamble to the Supreme Court Code of Conduct. The undersigned justices are promulgating this code of conduct to set out succinctly and gather in one place the ethics, rules, and principles that guide the conduct of the members of the court. For the most part, these rules and principles are not new. The court has long had the equivalent of common law ethics rules, that is, a body of rules derived from a variety of sources, including statutory provisions, the code that applies to their members of the federal judiciary, ethics advisory opinions issued by judicial conference committees on codes of conduct, and historic practice. The absence of a code, however, has led in recent years to the misunderstanding that the justices of the court, unlike all other jurists in the country, regard themselves as unrestricted by any ethics rules. To dispel this misunderstanding, we are issuing this code, which largely represents a codification of principles that we have long regarded as governing our conduct. November 13th, 2023. Okay, so that's a little preamble to their little code of conduct explaining why they did this finally in 2023. But moving on to Canon 1, which is a justice should uphold the integrity and independence of the judiciary. A justice of the Supreme Court of the United States should maintain and observe high standards of conduct in order to preserve the integrity and independence of the federal judiciary. And, I mean, yeah, I guess that's a pretty general statement. So, okay, moving on to Canon 2. A justice should avoid impropriety and the appearance of impropriety. Before we go on, what is impropriety? Impropriety is an improper or indecorous act or remark. So, just not acting right. Letter A, respect for the law. Justice should respect and comply with the law and act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. B, outside influence. A justice should not allow family, social, political, financial, or other relationships to influence official conduct or judgment. A justice should neither knowingly lend the prestige of the judicial office to advance the private interest of the justice or others, nor knowingly convey or permit others to convey the impression that they are in a specific position to influence the justice. A justice should not testify voluntarily as a character witness. So involuntarily they can. But, I mean, just reading the first line, a justice should not allow family, social, political, financial, or other relationships to influence official conduct or judgment. I'll let you be the judge of that. C, non-discriminatory membership. A justice should not hold membership in any organization that practices invidious discrimination on the basis of race, sex, religion, or national origin. Okay. All right, so that's the first two canons of the Supreme Court Code of Justice. And before we get started in the slaughterhouse cases today, just want to make a quick stop by the Constitution, of course, so we can see what we're going to be talking about. And today it's in direct reference to the 14th Amendment, but before the 14th Amendment, we had something called the Constitution. And in Article 4, Section 2 of the Constitution, it states, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. Okay, so since they're putting two of each state in the several states, they're talking about two different kinds of citizenships there. And this is before we had a lot of states. So the United States citizenship and the state citizenship wasn't really an issue. You were just a citizen of your state, and that's just kind of how it was. And then through the Articles of Confederation, you kind of came together as a citizen of the whole being, but there was never really any official capacity to citizenship of the United States. And this is actually much further expounded on in the Articles of Confederation. I should link that here. Maybe I'll do that later. And so I do suggest going to read it because it does actually make this passage much more clear. But the reason I wanted to bring it up today is because of privileges and immunities, because you're going to hear that word a lot today. That's what the slaughterhouse cases are all about, privileges and immunities of the citizens of the United States. And do we have them or do we not? So, let's get started. Going to the syllabus of the slaughterhouse cases. And all of these pictures over here, these are all going to be pulled directly from my personal annotated PDF that you will receive when you download the Citizenship 1 educational package. So, here we start the case out. Okay, you know what, actually, before we move on to the syllabus, I just want to poison the well a little bit. Because, and the only reason I want to do this is because this is such a famous case, and there's a lot of contention around it, and there's a lot of misunderstanding around it, and I think this will help bring a lot of context to it. So, what I have found in the newspaper archives, searching for the slaughterhouse cases, is this interesting little article from the Times-Picayune? The Times-Picayune. Sounds like a Louisiana newspaper. From March 19th, 1972. And I have confirmed that that newspaper is what was in New Orleans at that time. And the gentleman here, Edwin L. Jewell, you can find him on the Library of Congress. He did live in Louisiana at that time. And a man named W.H. Cooley was the judge in the 6th District Court for these cases. This was before it got to the Supreme Court. But this would be in the appellate stage, and this is actually in reference to the bill that was passed before they got this act to protect the health of the city of New Orleans, which is what this case is all about. This is how the plaintiffs in error brought their, through a section in this act that we'll talk about later, but in reference to that bill, they are talking about bribery in the slaughterhouse cases. And here's just, we'll read this part right here. You can go into the rest of it. The entire article is right here. And it is in reference to the slaughterhouse cases. And I am actually, the case, because W.H. Cooley, he actually states in here, so what this article is actually referencing is this case, Oliver and Durbridge versus the Slaughterhouse Company, which the Slaughterhouse Company is the company that we're going to talk about today in the Supreme Court case. But this is just one of the many cases that got brought between the district courts for appeals before it got to the Supreme Court. And in this particular case, it's stated in here that Cooley puts it on the record that there was a bunch of bribery involved in passing the bill and during the slaughterhouse cases and before. And this article is from March 14th, 1872. And we'll discover later. I can't remember the exact date, but we'll see in the case where the exact date of the slaughterhouse cases in the Supreme Court was adjudicated, and it is after March 14th, 1872. So the best I can tell is that this is in direct reference to the slaughterhouse cases that we're going to talk about today. So there's my little poison for the well before we get started. So without further ado, let's jump in to the syllabus. And like I said, this is the statement, or this is who was here, the Butchers Benevolent Association of New Orleans versus the Crescent City Livestock Landing and Slaughterhouse Company, which that's the slaughterhouse company we just referenced. These are all the people involved. And it's, we'll learn later that there was actually more than just the Butchers Union involved. So, how did we get here? First, the legislature of Louisiana on March 8th, 1869, passed an act granting to a corporation created by it exclusive right for 25 years to have and maintain slaughterhouses, landings for cattle, and yards for enclosing cattle intended for sale or slaughter within the parish of New Orleans, Jefferson, and St. Bernard. In that state, a territory which it was said contained 1,154 square miles, which, if you're into numbers, that's a 9/11 encode, just saying, including the city of New Orleans and a population of between 200,000 and 300,000 people, prohibiting all other persons from building, keeping, or having slaughterhouse landings for cattle and yards for cattle intended for the sale or slaughter within those limits, and requiring that all cattle and other animals intended for sale or slaughter in the district should be brought to the yard and slaughterhouses of the corporation, and authorizing the corporation to exact certain prescribed fees for the use of its wharves and for each animal landed, and certain prescribed fees for each animal slaughtered, besides the head, feet, gore, and entrails, except of swine, which I find very interesting, but that's for different reasons. Held that this grant of exclusive right or privileges granted by proper limitation of the prices of the prices to be charged, and imposing the duty of providing ample conveniences with permissions to all owners of stock to land and of all butchers to slaughter at those places, was a police regulation for the health and comfort of the people, within the power of the state legislation, unaffected by the Constitution of the United States, previous to the adoption of the 13th and 14th Articles of Amendment. So basically what they're saying there is that the Louisiana legislature, they passed an act in March of 1869, and that's this act, an act for the health of the city of New Orleans, to locate the stock landings, slaughterhouse cases, and to incorporate the Crescent City Livestock Landing and Slaughterhouse Company. So we don't really need to go too deep into that, but if you are interested, that is the act that brought them here and that caused this entire mess. So as you see from the article we just read, this was in battle, and it'll say later that there was hundreds of suits brought. But moving on. Okay, so in point 2, they're talking about a Parliament of Great Britain and the slaughterhouse country have always exercised the power of granting exclusive rights, which is true. There's always been the power of Parliament and state legislatures to grant exclusive rights, but there is a non-equivalence right there, and it will be explained later why that is a non-equivalence. Such power is not forbidden by the 13 articles, by the 13th Article of Amendment and the first section of the 14th Article. The main purpose of all the last 3 amendments was the freedom of the African race, the security and perpetuation of that freedom, and their protection from the oppression of the white men who had formerly held them in slavery. So there's the stating that it's always been a right for the legislator to grant exclusive privileges. While the 13th Article of Amendment was intended primarily to abolish African slavery, it equally forbids Mexican peonage of the Chinese coolie trade when they amount to slavery or involuntary servitude, and the use of the word servitude is intended to prohibit all forms of involuntary slavery of whatever class or name. Okay, and that's just a little review of what the 13th Article of Amendment was for, and then we keep going further. The first clause of the 14th Article was primarily intended to confer citizenship on the Negro race, and secondly, to give definition of citizenship of the United States and citizenship of the state, and it recognizes the distinction between citizenship of a state and citizenship of the United States by those definitions. So, what they just stated there is the entire, one of the main purposes of this entire case is, or of the 14th Amendment, was primarily intended to confer citizenship on the Negro race. So the black people, the freed slaves were, the slaves were freed, and they didn't have citizenship. So they were basically what's known as stateless, and that's something that nobody wants to be. So they needed to give citizenship to the slave race that was just freed in order for them to be able to function in our system. And secondly, the 14th Amendment gave definition to citizenship of the United States and citizenship of the states. And in addition to giving a definition to either of those things, it recognizes the distinction between citizenship of a state and citizenship of the United States by those definitions. So, quickly, let's review what is the 14th Amendment. The 14th Amendment, Section 1, because he just stated that there's two definitions within this 14th Amendment. And so I'm going to read it and see if you can pick out those definitions. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's where it is. That's what he's talking about. The first clause of the 14th Amendment. And he clearly states right here that this is in the slaughterhouse case, that was the purpose of the 14th Amendment. So anyways, moving on. I'm done harping on that because there's still debate out there on if there is a state citizenship and a United States. Is there two different things? Yeah, just said it right there. We haven't repealed the 14th Amendment, have we? Not as far as I'm aware of. So that means today, in 2025, as I'm recording this video, there is a citizenship of the United States and there is a citizenship of the states. Moving on. The second clause protects from the hostile legislation of the states the privileges and immunities of the citizens of the United States as distinguished from the privileges and immunities of the citizens of the states. So he's saying the second clause of this: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So basically what that states is that states are not allowed to make laws that would abridge the rights of any United States citizen. So if someone's a citizen of the United States but not a citizen of that particular state where they're visiting, no state is allowed to make a law that would discriminate against that person that is a citizen of the United States, as long as they are a citizen of the United States. If you're a citizen of France, I don't know what to tell you. Moving on. So, point 4 in the syllabus: the privileges and immunities of the citizens of the United States are those which arise out of the nature and essential character of the national government, the provisions of its constitution or its laws and treaties made in pursuance thereof, and it is these which are placed under the protection of Congress by this clause of the 14th Amendment. So, I just realized this. What they're stating here is the privileges and immunities of the citizens of the United States are those which arise out of the nature and essential character of the national government. So what I just realized is that what they're stating here is that the privileges and immunities of the citizens of the United States are only granted to you by provisions in the Constitution or its laws and treaties made in pursuance thereof, and it is these which are placed under the protection of Congress by this clause of the 14th Amendment. So what they're stating there in a very backhanded, fancy way is that the only privileges and immunities granted to you citizens of the United States are the ones given to you by the government. Okay? So you're claiming to be a proud United States citizen. Well, then you got to do everything the United States government says without question. You got to follow all codes and statutes. You got to pay taxes. You got to do this. You got to do that. You got to do everything because the codes and statutes say so. But what this is also saying, without saying it, and we will learn later, is that state citizens are completely different. So, moving on. The clause which forbids a state to deny any person the equal protection of the law, which was clearly intended to prevent the hostile discrimination against the Negro race, and for the purpose the clause confers ample power in Congress to secure his rights and his equality before the law. And basically what they're stating here is that that same clause preventing the states of discrimination was clearly intended to prevent hostile discrimination against the Negro race so familiar in the states where he had been a slave. So basically what they're saying is this is really targeted at the South to stop them from discriminating against the Negro race. And that is... Okay, no, we're still in the syllabus. That's just the court reporter points. So this is an error to the Supreme Court. What is an error? An error, in general, an error is a mistake or misconception. In legal context, an error is either a mistake of fact or a mistake of law. In general, a mistake of law will nullify or reverse a judgment in the case. On the other hand, the mistake of fact that a judge or jury relied on to reach a decision or verdict may or may not warrant reversal. A harmless error or court proceeding is one that does not, despite it occurring, affect or change the case's final result. So they're saying little mistakes won't be reversed these days, but the court system is way different than it was in this time. But that is what an error is a in general, it's a mistake or error that you feel the court made. So the plaintiffs are the ones in error. So we will hear that term later, plaintiffs in error. In the very beginning here, this particular, because there is actually 3 different slaughterhouse cases within the Supreme Court slaughterhouse cases. There was one in 1869 before this case, and there's actually one in 1884 after this case, because Louisiana changed their constitution, so so it got brought to the Supreme Court again, and it was actually reversed then. But we'll break that case down later. And I'm assuming that the case we were talking about in bribery is actually one of these 3 cases that did make it to the Supreme Court. Although I don't know that for sure. Don't quote me on that. But it says it grew out of an act of legislature out of the state of Louisiana, an act to protect the health of the city of New Orleans, to locate the stock landings and slaughterhouses, and to incorporate the Crescent City Livestock Landing and Slaughterhouse Company. So they needed to incorporate this business to give it exclusive rights, and that was passed March 8th, 1869. Moving on. Some hundreds of suits were brought on one side of the other. The butchers, not included in the monopoly as it were called, acting sometimes in combination in corporations and companies and sometimes by themselves. The same council, however, apparently representing much of them all. So that so everybody out of the hundreds of suits, basically the same council was representing all of these people. And it's stated somewhere in here about 400 people were not included in this thing out of 1,000 butchers that were in Louisiana at the time. So, in the ground of opposition to the slaughterhouse company's pretension was that the act of Louisiana legislature made a monopoly and was a violation of the most important provisions of the 13th and 14th Articles of Amendment to the Constitution of the United States. So what they are alleging is that because they granted a monopoly, that violated the 400 butchers' rights to free labor. All right, so moving on, in jurisdiction 1, we talked about in order to get to the Supreme Court, you need two things. That the first one is a constitutional provision, and then you need an act of Congress. And in order to get to the Supreme Court, in this case, they use the 25th section of the Federal Judiciary Act. Now, in the last episode, the 1789 Federal Judiciary Act was also used to get to the Supreme Court, but it was a different section of the Federal Judiciary Act. So that's what that's stating. That's how they got here. And so this is where we get back to the little newspaper article that we talked about earlier, and something I find very interesting, because this article is from March 14th, 1872, and don't you just find it interesting that the case being advanced was first heard on these January 11th, 1872, Mr. Justice Nelson being indisposed and not in his seat. Being ordered for re-argument, it was again heard February 3rd, 4th, and 5th, 1873. And now I do want to state, before I go any further than this, I am drafting a letter to the Louisiana Archives to see if they will send me a copy of the case referenced in here, because in there is when W.H. Cooley actually talks about the bribery involved in the case. So hopefully they'll get a hold of me, and then we can actually read the case together and really get some concrete confirmation on what was happening during that time. So anyways, moving on. We're almost done with the syllabus. Oh, actually, we are done with the syllabus. So I just wanted to say that before we moved on. Now I'll be done poisoning the well. Well, maybe. We'll see. But we're going to move on to the next section of the slaughterhouse, the 1873 slaughterhouse cases, which is the argument against monopolies. All right, so to give the argument against monopolies is a person named John A. Campbell. I actually have his Wikipedia page linked right there if you want to check it out. And a person named J.Q.A. Fellows. I wasn't able to find anything about him. But they're the ones that gave the argument against monopolies. And just something important to point out here, the reporter cannot pretend to give more than such an abstract of the argument as may show to what the opinion of the court was meant to be responsive. So the court reporter apparently didn't catch the conversation very well. But it does open up with this great little quote here, quoting Thayer's. I didn't pull his English law, so I'm not too concerned about it. I'm not going to pull too much English law references unless I find it really relevant. But this is a quote that I wanted to read. The right to oneself, to one's own faculties, physical and intellectual, one's own brain, eyes, hands, feet, in a word, to his soul and body, was an incontestable right, one of whose enjoyment and exercise by its owner no one could complain, and one which no one could take away. More than this, the obligation to labor was a duty, a thing ordained of God, and which is substituted and which, if submitted to faithfully, secured a blessing to the human family. So basically what they're stating there is keep your hands off my money, and which I agree with. There's a couple of these quotes in here, and I really like this. And what this is in reference to is back when in like the feudal days, in the feudal system, and that's what we're going to talk about right here. They go on to describe what it was like when it was called the case against monopolies was going on, and the Queen's reign was in danger. So I just want to read this verbatim because I do find it interesting, and I want to see if you see any parallels with today. It was in the Parliament of 1601 that the opposition, which had during 40 years been silently gathered and husbanding strength, fought its first great battle and won its first victory. The ground was well chosen, though English sovereigns had always been entrusted with the supreme direction of commercial police. It was their undoubted prerogative to regulate coins, weights, measures, and appoint fairs, markets, and ports. The line which bounded these authorities over trade had, as usual, been but loosely drawn. They therefore, as usual, encroached on the province which rightfully belonged to the legislature. The encroachment was, as usual, patiently borne till it became serious. The encroachment was, as usual, patiently borne till it became serious. Sound familiar? But at length the Queen took upon herself to grant patents of monopoly by scores. There was scarcely a family in the realm that did not feel itself aggrieved by the oppression and extortion which the abuse naturally caused. Iron, oil, vinegar, coal, lead, starch, yarn, leather, glass could be bought only at exorbitant prices. The House of Commons met in an angry and determined mood. It was in vain that a courtly minority blamed the Speaker for suffering the acts of the Queen's Highness to be called in question. The language of the discontented party was high and menacing, and was echoed by the voice of the whole nation. The coach of the chief minister of the crown was surrounded by an indignant population who cursed monopolies and exclaimed that the prerogative should not be allowed to touch the old liberties of England. So that was back in 1601. It was called, why don't I have cases? The case of monopolies is what they are referencing right there. You can read all about it right here if you so choose. Macaulay proceeded to say that the Queen's reign was in danger of shameful and disgraceful end, but that she, with admirable judgment, declined the contest and redressed the grievance, and, in touching language, thanked the Commons for their tender care of the Commonwealth. So she seen that shit was about to hit the fan, and she's like, all right, I'll stop. So, and another man named John Culpeper goes on to say about monopolies: the great grievances of our ancestors about that time that they largely left England was this very subject. So talking about all the people escaping England to come here in the 1600s, was one of their main grievances. Culpeper says, they're a nest of wasps, a swarm of vermin which have overcrept the land. Like the frogs of Egypt, they have gotten possession of our dwellings, and we have scarce a room free from them. They sup in our cup, they dip in our dish, they sit by our fire. Does that sound familiar of some governments today? We find them in the dye-fat washbowl and powdering tub. They share with the butter in our box. They will not bait us a pin. We may not buy our clothes without their brokerage. They are the leeches that have sucked the Commonwealth so hard that it is almost heretical. Mr. Speaker, I have echoed to you the cries of the kingdom. I will tell you their hopes. They took to heaven for a blessing on this parliament. Okay, and like it was previously stated, that was the court reporter's kind of best interpretation of what the gentlemen were giving on the argument against monopolies. And now they're going on to talk about the act of the Louisiana legislature was in the face of all of these principles. They're talking about everything we just talked about was in the face of that. No, there's no freedom for a man to own his own labor. It made it unlawful for men to use their own land for their own purposes. The act of the Louisiana legislature, because basically it told them you cannot butcher in your own home anymore, you must go to these men's facilities. Made it unlawful to any except the 17 of this company to exercise lawful and necessary business for which others were as competent as they. The act was a pure monopoly, as such, against common right and void at common law of England, and it was equally void by our own law. The cases of Norwich Gas Company v. the Norwich Gas Light Company, the City of Chicago v. Ruoff, and the Mayor of the City of Hudson v. Thorne, a case in New York where in harmony with Koch's great case and declared that monopolies are against common right. So they now I have all three of those cases linked up here. Oh, oops, I gotta pull that one off my Google Drive, but I will have that one linked up here. The other two are here if you would like to read those cases where they state that they declared monopolies against common right, which could be interpreted as common law, and but a very important distinction as we go through this, and especially with these older cases, common law today is not what common law was pre-1938. But that's a different discussion for a different time. We need to keep moving here. Quickly. What harmony was found with Lord Koch? That a monopoly is against the common law, like I just said, and that it is against divers of the Act of Parliament. The Learned Counsel read Sir Coke's report of the judgment in the case, which was given fully in the brief at length, seeking to apply the case before the court. So they read Edwin Coke's entire case in the case of monopolies before the court, but the court reporter didn't find it relevant for the case, so they didn't include it. Okay. So, moving on, it states, but if the monopolies were not void at common law, it would be so under both the 13th and 14th Amendment. So, if this wasn't against the common law, even if they're saying, even if what Sir Coke said is true, or is false, and monopolies are actually not void at common law, then at the 13th and 14th Amendment they would be, so the judgment still needs to be reversed. The 13th Amendment prohibits slavery and involuntary servitude. The expressions are ancient ones and were familiar even before the time when they appeared in the Great Ordinance of 1787 for the government of our vast northwestern territory. And I do have that right here if you want to read it. Okay, and on page 50 they go on to state, now the act of which we complain has made of 3 parishes of Louisiana quote unquote enthralled ground. The 17 have restricted not only the inhabitants of the parish, but of all other portions of the earth who may have cattle or animals for sale or for food, to land them at the wharves of the company, to keep them in their pens, yards, stables, and to prepare them for the market. Their arbiter of or slaughterhouse, lest some competitor may present more tempting or convenient arguments, the act directs that all of these shall be closed on a particular day, and prohibits any one from having, keeping, or establishing any other, and a peremptory command is given that all animals shall be sheltered, preserved, and protected by the corporation and by none other under heavy penalties. So before we move on, and what is enthrall? What's the definition of enthrall? To hold spellbound. So what they're stating here is they turn this into a spellbound ground for these 17, and have to bind up the inhabitants of that enthralled ground. So they've basically, what he's saying is they've tied their hands. And he goes on to state, is this not a servitude? Might it not be so considered in a strict sense? It is like the thirlage of the Scotch law, banalities of the seigneurial France. And what is seigneurial? Seigneurialism was a system of rural organization and land tenure used in the 18th century France. The basis of the seigneurial system, which originated from the medieval feudalism, was almost entirely economic. It required peasants who occupied land owned by a seigneur to provide him a feudal duties and unpaid labor. These obligations and the seigneurial system that underpinned them were significant sources of dissatisfaction and grievance in the late 18th century. So he's saying, isn't this the same thing? Aren't we doing the same thing to the people who are butchering animals for sale in Louisiana? Number 3, the act is even more plainly in the face of the 14th Amendment. That amendment was a development of the 13th and is a more comprehensive exposition of the principles which lie at the foundation of the 13th. Nowhere in the Constitution is it declared what a citizen is, but in the 14th Amendment it is. The 14th Amendment does define citizenship and the relation of citizens to the state and federal government. It ordains that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Citizenship in a state is made by residents and without reference to the consent of the state. Yet, by the same amendment, when it exists, no state can abridge its privileges and immunities. The doctrine of the States' Rights Party, led in modern times by Mr. Calhoun, was that there was no citizenship in the whole United States except sub modo and by permission of the states. Okay, so what is sub modo? Sub modo is a Latin term which means subject to alteration or requirement. In a contract, sub modo, the agreement between the parties may be altered or limited within a certain parameters. An agreement as to property license and contracts of any type can be sub modo. So, no citizenship of the except sub modo and by the permission of the states. And yeah, seems to be right about that. Okay, and then we move on to page 54, where it continues to talk about the 14th Amendment. From whatever cause originating or whatever special and present or pressing purpose past, the 14th Amendment is not confined to the population that had been servile or to which had any of the disabilities or disqualifications arising from race or from contract. The vast number of laborers in mines, manufacturers, commerce, as well as the laborers on the plantations are defended against the unequal legislation of the states. Nor is the amendment confined in its application to laboring men. The mandate is universal in its application to persons of every class and condition. Okay, so leading us to page 55, the only question is this. When a state passes a law depriving 1,000 people who have acquired valuable property and who, through its instrumentalities, are engaged in an honest and necessary business, which they understand of their rights to use such their own property and to labor in such their honest and necessary business, and gives a monopoly embracing the whole subject, including the right to labor in such business, to 17 other persons, whether the state has abridged any of the privileges or immunities of these 1,000 persons. So in order to answer that question, we must first ask, what are privileges and immunities in the sense of the Constitution? They are undoubtedly the personal and civil rights which usage, tradition, the habits of society, written law, and the common sentiments of the people have recognized as forming the basis of the institutions of the country. The first clause in the 14th Amendment does not deal with any interstate relations. That depend in any manner upon the state law, nor is any standard among the states referred to for the ascertainment of these privileges and immunities. It assumes that there were privileges and immunities that belong to the American citizen, and the state is commanded neither to make them nor to enforce any law that will abridge them. So the first clause of the 14th Amendment, it assumes that there were privileges and immunities that belong to an American, and that the state is commanded neither to make nor enforce any law that will abridge them. Okay, now that we have gone to define privileges and immunities, the right to one's labor, the right to one's self physically and intellectually, and to the product of one's own faculties is past doubt property, and property of a sacred kind. Yet this property is destroyed by this act, destroyed not by due process of law, but by charter, a grant of privileges of monopoly, which allows such rights in this matter no one but a favored 17. So it's the act only gives rights to 17 people and deprives everybody else engaged in the same lawful labor. Okay, and for their final point here in the cases against monopolies, or the argument against monopolies here in the slaughterhouse cases, they bring up the police power point, and it will of course be sought to justify the act as an exercise of police power, a matter confessedly in the general scope within the jurisdiction of the state. But it does not follow there is no restraint on state power of legislation in police matters. The police power, okay. And then he goes on to list a couple of cases here: State Gibbons v. Ogden, and the passenger cases. I think I have that one too. Yeah, the passenger cases. I don't know why I didn't have that one before. And the passenger cases, those talk all about police powers, and you can read this for yourself. That's what it's kind of goes into a little bit, but I don't think we really need to get into it here, because in the opinion of the court, Justice Miller does go into that. All right, guys, so we finally made it to the part that everybody talks about in this case, which is the opinion of the court. And we actually still got to go just a little bit in to the, well, actually about 20 pages in almost, 15 anyways. And before it starts getting to the meat and potatoes of this case, but we'll just briefly go through here. Associate Justice Miller is the one who delivered the opinion of the court. You can read all about him here if you wish. And it was argued on he delivered the opinion on April 14th, 1873, which is about a year after our newspaper article that we read earlier. The timing of the justice that got sick or whatever, and they had to, well, actually, let's move on real quick because they talk about that. The hearing, one of the justices was absent, and it was found on consultation that there was a diversity of views among those who were present. Impressed with the gravity of the question raised in the argument, the court, under these circumstances, ordered that the case be placed on the calendar and regarded before a full bench. This argument was had early in February last. So they argued it in February. In April, Justice Miller delivered the opinion of the court. Okay, and here Justice Miller is just going in, explaining a little further what happened. We've kind of went through it, a review, but we went through it a little bit before. But he's basically explaining that through all of these suits, there was about, I think there was 400 or so in total. And of all of those, at the end, when all the dust settled, there was 3 people who had writs of error. And they are now before the court, and they have the right to be heard. That's and the motion to dismiss cannot prevail, because we went through a little bit earlier. They kind of tried to do a behind-the-scenes deal before this, which kind of lends credence to our little newspaper article before too, because they did try to settle this out of court before they got to court, but Justice Miller felt that these 3 plaintiffs had the right to be heard, which they do. He is correct about that. So let's move on and see what else he feels about it. The power here exercised by the legislature of Louisiana is one which has been, up to the present period in the constitutional history of this country, always conceded to belong to the state. However, it may now be questioned in some of its details. So now that the 14th Amendment has passed, they may question whether this is a legitimate police power. Okay, and here Justice Miller is simply stating that, well, actually, this is interesting. This power is, the police power that he's talking about, is and must be, from its very nature, incapable of any exact definition or limitation. So basically, the police power cannot be specifically defined. Upon it depends the security of social order, the life and health of citizens, the comfort of an existence in the thickly populated community, the environment of private and social life, and the beneficial use of property. He's quoting another eminent judge here. Quote, it extends to the protection of lives, limbs, health, comfort, and quiet of all persons, and the protection of all property within the state, and persons and property are subject to all kinds of restraints and burdens in order to secure the general comfort, health, and prosperity of the state. Of the perfect right of the legislature to do this, no question ever was, or upon acknowledged general principles ever can be made, so far as the natural persons are concerned. So they're really just defining what the police powers are as far as can be, because these states right there, it must be from its very nature incapable of any exact definition or limitation. So take that as you will. Okay, and so here I'm just gonna kind of breeze through this stuff a little bit. It's not really pertinent. It's really honestly not what you're here for, because we've kind of beaten the monopoly discussion with a dead horse. So basically what he's going through here is the legitimacy of the Louisiana legislature to grant police powers, and he cites McCulloch v. the state of Maryland for this in relation to the power of Congress to organize the Bank of the United States to aid the fiscal operation of the government. And that is a big non-equivalence there, Mr. Miller, but we're not going to get into that right now. And he goes on, it can readily be, and he talks about here that monopolies are more efficient than using police power, because you can just grant it to a corporation rather than having it run by the government, which ties into public-private partnerships. I'm sure you've heard that term floating around there. So, yeah, feel how you want about that. So, can any exclusive privileges be granted? That's the question that we're asking here. Okay, and he's Justice Miller is stating here. Yeah, the answer is yes, unless the some restraint in the exercise of that power be found in the Constitution of that state or in the amendments of the Constitution of the United States adopted since the date of that decision. If any such restraint is supposed to exist in the Constitution of the state, the Supreme Court of Louisiana having necessarily passed on the question, it would not be open to review in this court. So we talked a little bit about this in Jurisdiction 1. This is because the plaintiffs went in, these three plaintiffs went in under the 14th Amendment of the Constitution. This case poses a uniquely federal question. So that means that the even though that they brought the suit upon an act by the Louisiana legislature, they can take this to the Supreme Court because it has a uniquely federal question to it, because they're questioning the 13th, 14th, and 15th Amendments. Okay, and then he goes on to state, what are the plaintiffs in error actually alleging here? The plaintiffs in error accepting this issue allege that the statute is a violation of the Constitution of the United States in the several particulars. It's a violation of the Constitution, that's why it has uniquely federal question. That it creates an involuntary servitude forbidden by the 13th Article of Amendment, that it abridges the privileges and immunities of citizens of the United States, that it denies to the plaintiffs the equal protection of the laws, and that it deprives them of their property without due process of law, contrary to the provisions of the first section of the 14th Article of Amendment. So they brought this, that like I just stated, they brought this suit to the Supreme Court under the 13th and 14th Amendment. Okay, and in this next point here, this is why I do my best to cite every page that all of these points are from, so you can go through in the documented, and I leave a clean one or annotated, whichever you prefer, but you want to go through in the document yourself, and because in this section from pages 67 to 69, Justice Miller proceeds to give a short history of the political landscape before the Civil War and why the 13th and 14th Amendments were ratified. It's not really relevant. The exact points there, it's not really relevant to the points I'm trying to make right now, but it is a little window into law history, which I think is really important, and you should go read those pages for sure. You should read the entire entire case, but that is particularly important if you want to understand the history of the United States. Okay, and here Justice Miller is defining what the 13th Article of Amendment is saying, and I do think he makes some pretty interesting points here. So the 13th Article of Amendment in two sections seems hardly to admit of construction so vigorous is their expression and so appropriate to the purpose we have indicated. Neither slavery nor involuntary servitude, except as a punishment of crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. 2. Congress shall have the power to enforce this article by appropriate legislation. That a personal servitude was meant is proved by the use of the word involuntarily, which I think this is an interesting point for Justice Miller to make, and goes to show you how far thinking has come, because he states that the word involuntarily, which can only apply to human beings. We're going to have a disagreement on that. You can definitely make any of God's creatures do something involuntarily, and it's pretty obvious when you're doing it, so we're going to disagree on that point, Mr. Miller. The exception of servitude as a punishment for crime gives an idea that the class of servitude that is meant, the word servitude is of a larger meaning than slavery, as the latter is popularly understood in this country, and the obvious purpose was to forbid all shades and conditions of African slavery. It was very well understood that in the form of apprenticeship for long terms, as it had been practiced in the West India Islands, as it had been practiced in the West India Island. I just found that it was very well understood that in the form of apprenticeship for long terms, as it had been practiced in the West India Islands, on the abolishment of slavery by English government, or by reducing the slavery to the condition of serfs attached to the plantation, the purpose of this article might have been evaded if only the word slavery had been used. That's an interesting point to make, Mr. Miller. He's obviously talking about the West India Islands when the British Empire freed the slaves from I'm gonna have to look into that more, because I think he's being tricky there. I don't know. Long in that form of apprenticeship for long term. So he's saying it had been practiced in that whatever. Not relevant to today. Sorry. We'll move on. Okay. Had been used the case of apprentice slaves held under the law of Maryland, liberated by Chief Justice Chase on the writ of habeas corpus under this article, illustrates this course of observation, and it is all that we deem necessary to say on the application of this article on the statute of Louisiana, now under consideration. Okay, and here, might be poisoning the well a little bit more, but, yeah, me and Justice Miller definitely disagree on the history of the Civil War, because, and he knows that there's a lot of, that there's going to be a lot of misconception and falsehood, because these circumstances, whatever of falsehood or misconception may have been mingled with their presentation, forced upon the statesmen who had conducted the federal government in safety through the crisis of the rebellion, and who supposed that by the 13th Article of Amendment they had secured the result of their labor, the conviction that something more was necessary in the way of the constitutional protection to the unfortunate race who had suffered so much. They accordingly passed through Congress the proposition of for the 14th Amendment, and they declined to treat as restored to the full participation in the government of the United States, which had been in insurrection until they ratified that article by a formal vote of their legislative bodies. And yeah, this whole paragraph right here, it's kind of propaganda, honestly, because I have this article right here, and oh yeah, you can just download it right here, and it's from volume 13, part 12 of the Congressional Record of 90th Congressional Record, and they talk all about the 14th Amendment being a tool of usurpation there. And you'll see when we get to the very last line of this case, they saw it coming. They knew what these people were doing. They knew what was happening. They knew the consequences of the actions of this case right here. Everybody knew the gravity of this case. And that's why I think it's so interesting, the outcome of it and everything that's happened ever since. But moving on. And then here, Justice Miller is really just completing his history of the 13th, 14th, and 15th Amendment. He says, since, they couldn't vote, because we all know how legitimate voting is. You got to get them votes in there. But hence the 15th Amendment, which declares that the right of a citizen of the United States to vote shall not be denied or abridged by any state on account of race, color, or previous condition of servitude. The Negro, having by the 14th Amendment been declared to be a citizen of the United States, is thus made a voter of every state of the Union. Maybe it was more important back then, because I imagine it was probably a lot harder to rig elections back then. Or maybe it was a lot easier, what do I know? They actually, in a great movie, Gangs of New York, they kind of give a little behind the scenes on how it was happening in New York back then, and something called Tammany Hall, which you should definitely read about. But here we finally made it to the meat and potatoes of the whole case. It starts on page 72 of the opinion, and this is where we're going to get into it. This is where Justice Miller really breaks it down and defines the difference of citizenships. And here, this is one of the most important points that actually I'm just going to read this verbatim, because here Justice Miller is telling us that these amendments were only meant for freed African slaves. That's literally what he's saying. We repeat then, in the light of the recapitulation of events almost too recent to be called history, because the Civil War was 1865, this is 1873, it is almost too recent to be called history, but with which we are familiar to us all, and on the most casual examination of the language of these amendments, no one can fail to be impressed with the one pervading purpose found in them all, lying at the foundation of each, and without which none of them would have been even suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made free man and citizens from the oppression of those who had formerly exercised unlimited dominion over him. It is true that only the 15th Amendment in terms mentions the Negro race by speaking his color and his slavery, but it is just as true that each of the other articles was addressed to the grievances of that race and designed to remedy them as the 15th. That's what he's stating there. Even though the 15th Amendment is the only one that actually calls it by name, the 13th, 14th, and 15th Amendment, each of those articles, each of the other articles was addressed to the grievance of that race and designed to remedy them as the 15th. And I'm just going to read this verbatim because it's interesting points that he's making. We do not say that no one else but the Negro race can share in this protection. Both the language and spirit of these articles are to have their fair and just weight in the questions of construction. Undoubtedly, while Negro slavery alone was in the mind of Congress, which proposed the 13th article, it forbids any other kind of slavery now or hereafter. If Mexican peonage or the Chinese coolie labor system shall develop slavery, of the Mexican or Chinese race within our territory, this amendment may safely be trusted to make it void. And so, if other rights are assailed by the states which properly and necessarily fall within the protection of these articles, that protection will apply, though the party interested may not be of African descent. But what we do say, and what we wish to be understood, is that in any fair and just construction of any section of the phrase of these amendments, it is necessary to look at the purpose which we have said was the pervading spirit of them all, the evil which they were designed to remedy in the process of continued addition to the Constitution, until that purpose was supported to be accomplished as far as constitutional law can be accomplished. So they're basically all Justice Miller saying that, he's just stated it was only meant for the African race, but we do not say that only the Africans can join this. If there's Mexican or Chinese slaves, then obviously they can bring suit to the federal government and find remedy for this. But he goes on to state our attention is more specifically drawn to the 14th Article of Amendment. This first section of the 14th Article opens with a definition of citizenship, not only citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. It had been the occasion of much discussion in the courts by the executive departments and in public journals. And in the public journals, it had been said by eminent judges that no man was a citizen of the United States except as he was a citizen of the states composing the Union. Those, therefore, who had been born and resided always in the District of Columbia or the territories, though within the United States, were not citizens. Whether this proposition was sound or not had never been judicially decided, but it had been held by this court in the celebrated Dred Scott case only a few years before the outbreak of the Civil War that a man of African descent, whether a slave or not, was not and could not be a citizen of a state or of the United States. This decision, while it met the condemnation of some of the ablest statesmen and constitutional lawyers of the country, it had never been overruled, and if it was to be accepted as a constitutional limitation of the right of citizenship, then all the Negro race who had recently been made freemen were still not only not citizens, but were incapable of being so by anything short of an amendment of the Constitution. To remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States and also citizenship of the states, the first clause of this first section was framed. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The first observation we have to make on this clause is that it puts at rest both the question which we stated to have been the subject of differences of opinion. It declares that persons may be citizens of the United States without regard to their citizenship of a particular state, and it overturns the Dred Scott decision by making all persons born within the United States and subject to its jurisdiction citizens of the United States. That its main purpose was to establish the citizenship of the Negro can admit of no doubt. The phrase subject to its jurisdiction was intended to exclude from its operation children of ministers, councils, and citizens or subject of foreign states born within the United States. And he's talking about Indians there. I don't know why he doesn't just state it, but he means Indians. The next observation is more important in view of the argument of counsel in the present case. It is that the distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter. So a necessary element to convert a United States citizen into a state citizen. He must reside within that state to make him a citizen of it, but it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. So to be a state citizen, you have to live within that state, you have to reside within that state. And there's a lot of hoopla about the word residence, but it is actually a constitutional term. So I actually use both terms, privately residing, privately domiciling outside of a military jurisdiction. He must reside within a state to be a citizen, but you only have to be born. You can be born in any state, born or naturalized, and this is how it still is. You just be born or naturalized, and naturalization means you just say you're a citizen of the United States, and you are then a citizen of the Union. It is quite clear then that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual. So not only are there two different citizenships, but there is a big distinction between those citizenships. Okay, and just we think this distinction and its explicit recognition in this amendment of great weight in this argument, because the next paragraph of the same section, which is the one mainly relied on by the plaintiffs in error, speaks only of privileges and immunities of citizens of the United States and does not speak of those citizens of the several states. The argument, however, in favor of the plaintiffs rests wholly on the assumption that the citizenship is the same and the privileges and immunities granted by the clause are the same. The language is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. It is little remarkable if this clause was intended as a protection to the citizens of a state against the legislative power of his own state, that the word citizen of the state should be left out when it is so carefully used and used in contradistinction to citizens of the United States. In the very sentence which precedes it, it is too clear for the argument that the change in phraseology was adopted understandingly and with purpose. So he's saying the people who wrote this article of amendment, they knew exactly what they were doing. They intended to define the difference between these two citizenships, and that the change in phraseology is what makes the distinction of the privileges and immunities between these. If then there is a difference between the privileges and immunities belonging to a citizen of the United States as such and those belonging to the citizen of a state as such, the latter must rest for their security and protection where they have therefore rested, for they are not embraced by this paragraph of amendment. So what he's saying is that the state citizens must have their rights protected by whatever state they're living in, and the state citizens are not embraced by this article of amendment. State citizens get no additional rights, privileges, and immunities, whatever you want to call it. Well, it's privileges and immunities. That's what it's actually called. State citizens get no extra. The first occurrence of the word privileges and immunities in our constitutional history is to be found in the 4th article of the of the Articles of Confederation. It declares that the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in the Union, the free inhabitants of each of the states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all the privileges and immunities of free citizens in the several states. And the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants therefore respectively. So this is the occurrence of, like, in the old Articles of the Confederation. That's where they first really defined what privileges and immunities are. And you can see right here that the right to travel between states is a privilege and immunity of the state citizens. Moving on, though. In the Constitution of the United States, which superseded the Articles of Confederation, meaning it overtook. Supersede means it takes over in place of. The articles superseded the Articles of Confederation. The corresponding provision is found in Section 2 of the 4th Article in the following words: the citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. There can be but little question that the purpose of both these provisions is the same, and that the privileges and immunities intended are the same in each. In the Article of the Confederation, we have some of these specifically mentioned, and enough, perhaps, to give some general idea of the class of civil rights meant by the phrase. Fortunately, we are not without judicial construction of this clause of construction. The first and the leading case on the subject is that of Corfield v. Coryell, decided by Mr. Justice Washington in the Circuit Court of the District of Pennsylvania in 1823. And that, Corfield v. Coryell, I have that right here. You can read the whole case, should you choose. And actually, this is going to be the next educational course I put together is Corfield v. Coryell, because it is mentioned so much, not only in this case, but a lot of other cases, and it's because this is the first case that defines privileges and immunities. So, we are going to go there. Okay. And so, the inquiry, he says that our privileges and immunities is what are privileges and immunities of the several states. We feel no hesitation in confining these expressions to those privileges and immunities which are fundamental. And he's quoting directly from Corfield v. Coryell right now. He's quoting right from Corfield v. Coryell. What are the privileges and immunities of the citizens of the several states? What are the privileges and immunities of the citizens of the state citizens? That's what he's saying. Of the state citizens. What are their privileges and immunities that they have? We feel no hesitation in confining these expression to those privileges and immunities which are fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign. From the time of their becoming free, independent, and sovereign. That the states, that's what he's talking about. The states are free, independent, and sovereign. What these fundamental principles are, it would be more tedious than difficult to enumerate. They all, however, be comprehended under the following general heads: protection by the government, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject nevertheless to such restraints as the government may prescribe for the general good of the whole. So, state citizens have fundamental rights. And as I just previously stated, the Corfield v. Coryell has been cited in so many cases, and Justice Miller cites just two of them right here. Ward v. Maryland and Paul v. Virginia. I have both of these up here if you'd like to read those too. And yeah, those those are the other cases that have also stated. Those are other cases that have also cited Corfield v. Coryell. Moving on. Okay, and we're going to dig into this point a little bit, because this is one of my favorite points that Justice Miller makes. Much as I disagree with him, this is a good point that he makes. In the case of Paul v. Virginia, the court, in expounding this clause of the Constitution, says that the privileges and immunities secured to the citizens of each state in the several states by the provision in question are those privileges and immunities which are common to the citizens in the latter states under their constitution and laws by virtue of being citizens. The constitutional provisions there alluded to did not create, and this is Article 4, Section 2, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. And he's talking about that right here. These constitutional provisions there alluded to did not create those rights, which is called privileges and immunities of citizens of the states. It threw around them in the clause no security for citizens of the state in which they were claimed or exercised, nor did it profess to control the power of the state government over the rights of the citizens. Its sole purpose was to declare to the several states that whatever those rights as you grant or establish them to your own citizens, or as you limit or qualify or impose restrictions on their exercise, the same neither more nor less shall be measures of rights of citizens of other states within your jurisdiction. So he's stating there, before we had a citizenship of the United States, we had the Article 4, Section 2 of the Constitution, and all that was stating is, he's stating Article 4, Section 2 didn't give the United States government power to restrict, impose, limit, grant, qualify rights on any of the states. All it's stating is that if a citizen of New York goes to Maryland can't pass any laws. It can't pass any laws to abridge the rights of the citizen of New York. Saying that's all the Fourth Article of Amendment was there to do. And just further expounding on that previous point, he's right here. Justice Miller's really a states' right advocate, which is hilarious after the Civil War and his defense of it. But it would be the vainest show of learning to attempt to prove by citation of authority that up to the adoption of the recent amendment, no claim or pretense was set up that those rights depended on the federal government for their existence or protection, beyond the very few express limitations which the federal government imposed upon the states, such, for instance, as the prohibition against ex post facto laws, bills of attainder, and laws impairing the obligation of contracts. But with the exception of these and few other restrictions, the entire domain of the privileges and immunities of the citizens of the states, as above defined, lay within the constitutional and legislative power of the states. It lays within the state constitution, and without that of the federal government. So the power to grant privileges and immunities, all that stuff lays within the power of the states and without that of the federal government. Was it the purpose of the 14th Amendment by simple declaration that no state could make or enforce any law which shall abridge the privileges and immunities of the citizens of the United States, transfer the security and protection of all the civil rights which we have mentioned from the state to the federal government, and where it is declared that Congress shall have the power to enforce this article, was it intended to bring within the power of Congress the entire domain of civil rights heretofore belonging exclusively to the states. So what he's stating is, was it the intention of the 14th Amendment to completely abridge the states' rights? To abridge state rights? Was it the intention of the 14th Amendment to give all civil rights, the adjudication of all civil rights from the states to the United States government? And then he goes on to state, all this and more must follow if the proposition of the plaintiff in error be sound. And in this paragraph here, Justice Miller further explains the previous paragraph and his adherence to the Constitution, giving a hypothetical scenario. If he were to reverse the judgment, for not only are these rights, United States citizens, subject to the control of Congress, wherever in its discretion any of them are supposed to be abridged by state legislation, but that body may also pass laws in advance limiting and restricting limiting and restricting the exercise of legislative power by the states in their most ordinary and usual functions. So what he's saying here is that United States citizens their privileges and immunities are completely subject to Congress. Congress basically are the gods of the United States citizens. And he's basically stating they have no fundamental rights right here, and Congress has all power over them. And he's stating that it wasn't the intention of the 14th Amendment to be any other way. We are convinced that no such result was intended by the Congress which proposed these amendments, nor by the legislature of the states which ratified them. Then Justice Miller goes on to state what are the additional privileges and immunities of citizens of the United States. But lest it should be said that no such privileges and immunities are to be found if those we have been considered are excluded, we venture to suggest some which owe their existence to the federal government, its national character, its constitution, or its laws. One of these is well described in the case of Crandall v. Nevada. It is said to be the right of the citizen of this great country, protected by implied guarantees of the Constitution, to come to the seat of government to assert any claim he may have upon the government, to transact any business he may have with it, to seek protection, to share its office, to engage in administrating its functions. He has the right of free access to seaports through which all operations of foreign commerce are conducted, to sub-treasuries, land offices, and courts of justice of the several states. So he's saying that you can sue the government, you can use the ports, you can basically travel freely, you can engage in its administrative functions. And quoting from the language of Chief Justice Taney in another case, it is said that for all the great purposes for which the federal government was established, we are only one people with one common country. We are all citizens of the United States. And it is as such citizens that their rights are supported in the court in Crandall v. Nevada. And this is privilege 2 of the United States citizen. And another privilege of this citizen of the United States is to demand the care and protection of the federal government over his life, liberty, and property when on the high seas or within the jurisdiction of a foreign government. Of this, there can be no doubt, nor that the right depends upon the character of the citizen of the United States. That right to peaceably assemble and petition for redress of grievances, the privileges of the writ of habeas corpuses, are of the right of citizens guaranteed by the federal Constitution. That right to use navigable waters of the United States, however they may penetrate the territory of the United States, all rights secured to our citizens by treaties and foreign nations are dependent upon citizenship of the United States and not citizenship of the states. One of these privileges is conferred by the very article under consideration. It is that a citizen of the United States can, of his own volition, become a citizen of any state of the Union by a bona fide residence therein, and with the same rights as other citizens of the state. To these may be added the rights secured by the 13th and 15th Articles of Amendment, and by other clauses of the 14th next to be considered. So those are the additional privileges and immunities granted to the United States citizen. And if you have a bona fide residence, what is bona fide? A bona fide is a Latin term, it means good faith, and is most frequently used in the context of a bona fide purchaser, which those are all equitable terms. But so if you are living in a state, if you're a citizen of the United States and you are living in a state and you claim citizenship of that state, then you can also have rights of the state citizens. Okay, near Justice Miller finally gets to it. But it is useless to pursue this branch of inquiry, since we are of the opinion that the rights claimed by these plaintiffs in error, if they have any existence, are not privileges and immunities of citizens of the United States within the meaning of the clause of the 14th Amendment under consideration. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of its laws. The argument has not been much pressed that the defendant's character deprives the plaintiff of their property without due process of law, or it denies equal protections of the law. So, the argument pressed by the plaintiffs in error that the defendant's character deprives the plaintiffs of their property without due process of law. He's claiming that that is not at all what the plaintiffs are arguing in the case. Nor shall any state deny any person within the jurisdiction the equal protection of the laws. In the light of the history of these amendments and the pervading purpose of them, which we have already discussed, it is not difficult to give a meaning of this clause. The existence of the laws in the state where the newly emancipated slaves reside, which discriminated with the gross injustice and hardship against them as a class, was the evil to be remedied by this clause, and by it such laws are forbidden. If, however, the state did not conform their laws to the requirements, then by the 5th section of the Article of Amendment, Congress, by the 5th section of the 14th Amendment, Congress was authorized to enforce it by suitable legislation. We doubt very much whether any action of a state not directed by way of discrimination against the Negro race as a class or on account of their race will ever be held to come within the purview of this provision. So he's stating, even though the 14th Amendment was, if 13th, 14th, and 15th were passed for the Negro race, he doubts that any suit will ever be held to come within the purview of this provision. It is so clearly a provision for that race in emergency that a strong case would be necessary for its application to any other. But as it is a state that is to be dealt with and not alone the validity of its laws, we may safely leave that matter until Congress shall have exercised its power, or some case of state oppression by denial of equal justice in its court shall have claimed a decision at our hands. We find no such case in the one before us, and do not deem it necessary to go over the argument again as it may have relation to this particular clause of the amendment. So, he's stating, sure, hypothetically, this could happen. A non-black resident of a state could somehow, some way, possibly bring suit under the 14th Amendment, but you would have to have a really, really, really strong case to do that. And he says, in this case, we find no such case in the one before us. And here we get to the conclusion of Justice Miller's case here. And I'm just going to read it verbatim because this is... it's pretty important. This is the judgment of the case. In the early history of the organization of the government, its statesmen seem to have divided on the line which should separate the power of national government from the state government. And though this line has never been very well defined in public opinion, such a division has continued from that day to this. The Bill of Rights shows a pervading sense of danger at the time from its federal power. The adoption of the first 11 amendments of the Constitution so soon after the original instrument was accepted shows a pervading sense of danger at the time from its federal power, and it cannot be denied that such jealousy continued to exist with many patriotic men until the breaking out of the Civil War. It was then discovered that the true danger to the perpetuity of the Union was in the capacity of the state's organization to combine and concentrate all the power of the state and of the contiguous states for a determined resistance to the general government. So that's a very interesting paragraph by Justice Miller right there, because he's stating that the reason that the entire Civil War happened is because the southern states were too organized. The Union was in the capacity of the state organizations to combine and concentrate all of the power of the state and of the contiguous states for a determined resistance to the general government. So what he's saying is, we didn't like what they were doing. We didn't like that they could they could tell us no. Because that's what the Civil War was about, was the North wanted the South to sign on to their debt, and the South told them no. And Justice Miller's like, we didn't like that. So we passed the 14th Amendment to, it's not going to happen again, boys. Unquestionably, this has given great force to the argument and added largely to the number of those who believe in the necessity of a strong national government. But whatever fluctuations may be seen in the history of public opinion on this subject, we think it will be found that this court has always held with a steady and even hand the balance between state and federal power. It almost sounds like he knew the dire consequences of his opinion here. And yeah, I'm going to disagree with you here. I don't, because the Civil War was not a steady hand on the balance of state and federal power. It was a complete federal takeover. That's what it was. It was they call it the War of Southern Rebellion. I call it the War of Northern Aggression, because that's exactly what it was. And the Rothschilds funded it. Ulysses S. Grant told them to bring 100,000 soldiers at a time to be slaughtered in mass to take over the southern states, because they didn't like that the states were organized and told them no. That's why I have a problem with Justice Miller here. So far, so much. But, well, that's it. The judgment of the Supreme Court of Louisiana in this case are affirmed. They're affirmed. So, meaning, have your monopoly, boys. I'm not going to infringe on I'm not going to overrule the state government. How dare I do that? I believe in states' rights. Even though I just explained to you in plain language the reason for the whole Civil War is that we didn't like that the states had rights. So, that's going to be it for Justice Miller's opinion, though. And now, so that's the official opinion of the court. But in this case, there's actually 3 dissenting opinions. Dissenting opinions are the opinions that we reviewed this in jurisdiction 1. But dissenting opinions are the ones that disagree with the opinion of the court. And this was a 5-4 decision. 5 in favor of the opinion, 4 not in favor of, and 3 of the 4 justices wrote an opinion. They felt so strongly about the danger of this case and the danger of this ruling that all 3 of them, and it's normal for judges to dissent. You know, sometimes they just vote dissenting, whatever. It's not, for them to write a dissenting opinion is a big deal. That means they felt strongly against this, and they felt so strongly against it that they felt they better put it down on paper and let people know. So we have 3 of those to go through. One of them is very long, which is the first one. That's Justice Field. And yeah, this is actually longer than Justice Miller's opinion. But yeah, we're going to get into it. All right, let's get into this first dissenting opinion. This one is a long one. I'm probably not going to hit all the points too thoroughly because a lot of it is review. He goes pretty deep in monopoly stuff, which we get it. Monopolies are against common law, but he hits Justice Field, he does his due diligence here because he rebuts every single point of Justice Miller's opinion, which is why I feel we don't need to go too deep into everything, but there are definitely some things in here. Yeah, here he's restating the case, sole and exclusive privileges, and he's stating about the the Act for the Protection of Health. City of New Orleans, it's granting sole privileges for 25 years. They were prior to the passage of the act, they were engaged in lawful and necessary business of procuring and bringing to the parish of Orleans, Jefferson, St. Bernard's animals suitable for food, and in preparing food for market. That in the prosecution of this business, they had provided in these parishes suitable establishments for landing, sheltering, keeping, and slaughtering cattle and the sale of meat. That with their association, about 400 persons were connected, and that in these parishes named, about 8,000 persons were engaged in procuring preparing and selling animals for food. So there's like 1,000 people doing this, and he's stating here that the substance of the averments was what was once lawful now is not, and that's why it's a violation of the 14th Amendment. So no one will doubt the abstract justice which lies in the position of the plaintiff in error, and I will endeavor to show that the position has some support in the fundamental law of the country. And what he's stating here is that there's no doubt the state has legitimate police powers, but under the pretense of prescribing a police regulation, the state cannot be permitted to encroach upon any of the just rights of the citizens, which the Constitution intended to secure against abridgment. Two provisions which can be called police regulations: one, slaughtering animals below the city of New Orleans; two, inspecting animals when these requirements are compiled with sanitary purposes of the act are accomplished. In all other particulars, the act is a mere grant to a corporation created by it of an exclusive of it by it of special and exclusive privileges. So he's stating that the slaughtering animals below the city of New Orleans and the inspection of animals, those are police powers that can be legislated by the Louisiana legislature. But the granting of a corporation is in all other particulars, the act is a mere grant to a corporation created by it of special and exclusive privileges. So in any other interpretation of this act is it's a monopoly through and through. No such objection could be possibly justified legislation removing such buildings from a large part of the state for the benefit of a single corporation. And this is an important point that I do want to hit on, because this is where Justice Field actually makes the distinction between what is a police what is police regulations and what is not a police regulation. It is also sought to justify the act in question on the same principle that exclusive grants of ferries, bridges, and turnpikes are sanctioned, but it can find no support there. Those grants are of franchises of public character. So ferries, bridges, and turnpikes, like you're going to be driving on those, you're going to be riding your horse and buggy, you're going to be taking your carts on these things. So they're of public character, not, it's not a business somebody is running. It's of a public character appertaining to the government. Their use usually requires the exercise of a sovereign right of eminent domain. It is for the government to determine when one of these shall be granted and the conditions upon which it shall be enjoyed. It is the duty of the government to provide suitable roads, bridges, and ferries for the convenience of the public, and if it chooses to devolve this duty to any extent or in any locality upon particular individuals or corporations, it may, of course, stipulate for such exclusive privileges connected with the franchises as it may deem proper without encroaching upon the freedom and just rights of others. So what they're saying is the government can find it appropriate to create monopolies in this instance without encroaching on the freedom or just rights of others. The grant with exclusive privileges of a right thus appertaining to the government is a very different thing from the grant with exclusive privileges of a right to pursue one of the ordinary trades or callings of life, which is a right appertaining solely to the individual. Nor is there any analogy between the Act of Louisiana and the legislation which confers upon the inventor of a new and useful improvement an exclusive right to make and sell to others his inventions. The government in this way only secures to the inventor the temporary enjoyment of that which, without him, would not have existed. It thus only recognizes in the inventor a temporary property in the product of his own brain. So those he clearly defines the difference between what Justice Miller is trying to state is a grant of exclusive privileges and why it's justified. And he's saying, no, that's that's a non-equivalence, and I do believe I said that earlier, that is a non-equivalence. And he further expounds on this point, which I think is a really great point to hit on. If exclusive privileges of this character can be granted to a corporation of 17 persons, they may, in the discretion of the legislature, be equally granted to a single individual. If they may be granted for 25 years, they may be equally granted for a century. And in perpetuity. If they may be granted for the landing and keeping of animals intended for sale or slaughter, they may be equally granted for the landing and storing of grain and other products of the earth, or for any article of commerce. If they may be granted for structures in which animal food is prepared for market, they may be equally granted for structures in which farinaceous or vegetable food is prepared. I'm assuming that has something to do with produce. I probably should have looked that word up. But they may be granted for any of the pursuits of human industry, even in the most simple and common form. Indeed, upon the theory on which the exclusive privileges granted by the act in question are sustained, there is no monopoly in the most odious form which may not be upheld. So he's saying, if you can grant this silly monopoly to these 17 people, you can grant a monopoly for anything. You guys are just out here going buck wild. Okay, and he goes on to state, the question presented here is one of the gravest importance, not merely to the party here, but to the whole country. It is nothing less than the question whether the recent amendments to the federal constitution protect citizens of the United States against the deprivation of their common rights by the state legislature. In my judgment, the 14th Amendment does afford such protection and was intended by Congress, which framed, and the states which adopted it. So, and we obviously disagree about the states adopting it legitimately, but he states in his judgment that the opinion of the court is a far too narrow reading of the 14th Amendment. The counsel for the plaintiff in error have contended that the act in question is also inhibited by the 13th Amendment. That amendment prohibits slavery and involuntary servitude except as a punishment for crime, but I have not supposed it was susceptible of a consideration which would cover the enactment in question. I have been so accustomed to regarding it as intended to meet that form of slavery which had previously prevailed in this country, and to which the recent Civil War owed its existence, that I was not prepared, nor am I yet, to give it the extent or force ascribed by the council. Still, it is evident that the language of the amendment is not used in a restrictive sense. It is not confined to African slavery alone. It is general and universal in its application. Slavery, in which men, as well as black men, is prohibited, and not merely slavery in a strict sense of the term, but involuntary servitude in every form. The word involuntary servitude have not been the subject of judicial legislation that I am aware of in this country, except that which is found in the Civil Rights Act, which we will hereafter notice. So he's starting to hit the 13th Amendment point here, and he's going to go into a little bit of the history of the Civil Rights Act, which I do actually think is a pretty important point to hit. So it is clear that they include something more than slavery in the strict sense of the term. They include also serfage, vassalage, villanage, peonage, and all other forms of compulsory service for the mere benefit or pleasure of others. Nor is it the full importance of the term. The abolition of slavery and an involuntary servitude was intended to make everyone born in this country a free man, and as such to give him the right to pursue ordinary avocations of life without other restraint than such as affects all others, and to enjoy equally with them the fruits of his labor. The Council of the Plaintiffs are therefore contend that wherever a law of a state or a law of the United States makes a discrimination between classes of persons which deprives the one class of the freedom of their property, or which makes a caste of them to subserve the power, pride, avarice, vanity, and or vengeances of other, their involuntary servitude exists within the meaning of the 13th Amendment. Okay, and here he starts getting into the Civil Rights Act. It is not necessary for the disposition of the present case in favor of the plaintiff's narrative to accept as entirely correct the conclusion of counsel. It, however, finds support in the Act of Congress known as the Civil Rights Act. So he's saying that this isn't actually a violation of the 14th or the 13th Amendment, but it is a violation of the Civil Rights Act, which was born out of the 13th Amendment. Citizens of the United States, such citizens of every race, and color, without regard to previous condition of slavery or involuntary servitude, shall have the same right in every state and territory in the United States as enjoyed by white citizens. To deny any such citizen equally in these rights and privileges with others was to the extent of the denial subjecting him to an involuntary servitude. Senator Trumbull states, any statute which deprives any citizen of civil rights which are secured to other citizens is an unjust encroachment upon his liberty in the fact of a badge of servitude, which by the Constitution is prohibited. Okay, and this is a great point by Justice Field here. By the Act of Louisiana, every man who pursues the business of preparing animal food for marketing must take his animals to the building of the favored company and must perform his work in them, and for the use of the buildings must pay a prescribed tribute to the company and leave a valuable portion of each animal slaughtered. He is not allowed to do his work in his own building, or take his animals to his own stables, or keep them in his own yards, even though they should be erected in the same district. The prohibition imposes by this act upon the butchers and dealers in cattle in these parishes, and the special privileges conferred upon the favored corporations are similar in the principle and odious in character as the restrictions imposed in the last century upon the peasantry in the same parts of France. So he's referencing the serfdom days here, and he's going to quote a French writer: to hunt on his own lands, to fish in his own waters, to grind on his own mill, to cook at his own oven, to dry his clothes on his own machines, to wet his instruments at his own grindstones, to make his own wine, his oils, and his cider at his own press, or to sell his commodities at the public market. The exclusive right to all these privileges was vested in the lords of the vicinage. The history of the most execrable tyranny of an ancient times offers nothing like this. This category of oppression cannot be applied to a free man or to the peasant except in violation of his rights. So he's saying they realized this back in the serf days, that making these men who could once do this lawfully in their own homes, in their own buildings, at their own place, on their own time, now are imposed with the duty of having to take their business to these people and pay them for using their building. It's a violation of their rights, and I agree with Justice Field on that point. But if the exclusive privileges conferred upon the Louisiana Corporation can be sustained, it is not perceived why exclusive privileges for the construction and keeping of ovens, machines, grindstones, wine presses, and for all numerous trades and pursuits of the prosecution of which buildings are required, may not be equally bestowed upon other corporations or private individuals and for periods of indefinite duration. So he's just bolstering his point that he made at the beginning of his argument. If they can do it for one, they can do it for all. So the 14th Amendment was adopted to obviate objections which had been raised and pressed with great force to the validity of the Civil Rights Act and to place common rights of American citizens as contradistinguished from U.S. citizens under the protection of the national government. The first clause of the 14th Amendment determines who are citizens of the United States and how their citizenship is created. John C. Calhoun calls the United States citizens the perfect nondescript. Mr. Justice Curtis has been generally accepted by the profession of this country as the one containing the soundest views of the constitutional law, and held that the Constitution, under the Constitution, citizenship of the United States in reference to natives was dependent upon citizenship in the several states under their Constitution and laws. In the Dred Scott case, this subject of citizenship of the United States was fully and elaborately discussed. The exposition, in the opinion of Mr. Justice Curtis, has been generally accepted by the profession of this country as the one containing the soundest views of constitutional law. And he held that under the Constitution, citizenship of the United States in reference to natives was dependent upon citizenship in the several states under their Constitution and laws. Oh, sorry, I just read that. Chief Justice Taney holds people of the United States and citizens synonymous, and that people of the respective states were the parties to the Constitution, that these people consisted of the free inhabitants of the states. I kind of broke down this paragraph right here because it's kind of confusing to understand, so I'm just going to read my excerpt. The first clause of the 14th Amendment changes this whole subject and removes it from the region of discussion and doubt. This is where Justice Field lays out his fundamental disagreement on the restrictions, the opinion of the court, put upon the 14th Amendment. It recognizes in express terms if it does not create citizens of the United States and it makes citizenship dependent upon the place of their birth or the fact of their adoption, and not upon the Constitution or laws of any state or condition of ancestry, a citizen of a state is now only a citizen of the United States residing in that state. Justice Field is stating that the entire purpose of the 14th Amendment was to bring all citizens of our great country into the one basket with the same privileges and immunities, by further stating a citizen, quote, a citizen of a state is now only a citizen of the United States residing in that state. The fundamental rights, privileges, and immunities which belong to him as a free man and a free citizen now belong to him as a citizen of the United States. He further goes on to state that the local customs and culture of wherever you domicile will obviously have an effect on the local institutions, but this is a result, quote, this is a result which follows from the constitution of society and can never be avoided, but in no other way can they be affected by the action of the state or by the residence of the citizen therein. They do not derive their existence from its legislation and cannot be destroyed by its powers, meaning that they are fundamental. The rights are fundamental. They do not derive their existence from legislation and cannot be destroyed by its power. That's a great little quote right there. The amendment does not attempt to confer any new privileges or immunities upon citizens or to enumerate or define those already existent. It assumes that there are such privileges and immunities which belong of right to citizens as such, and ordains that they shall not be abridged by state legislation. Justice Field clearly defines what he thinks the true intent and purpose of the 14th Amendment was in these two sentences. Then further goes on to state that if the amendment has no reference to the previous privileges and immunities belonging to citizens of the U.S., under the Constitution, it was a vain and idle enactment which accomplished nothing. So, if the amendment has no reference to the previous privileges and immunities, so he's saying if the 14th Amendment didn't confer any of these privileges and immunities onto the United States citizens, then the 14th Amendment was a vain and idle enactment which accomplished nothing. Or was it a tool of usurpation? But if the amendment refers to the natural and inalienable rights which belong to all citizens, the inhibition has a profound and significant consequence. So he's stating if these privileges and immunities are embraced by the 14th Amendment, then it's a profound tool of freedom that everybody can embrace. What are the privileges and immunities which are secured against abridgment by state legislation? In the first section of the Civil Rights Act of Congress has been given its interpretation to these terms, or at least has been stated some of the rights which, in its judgment, these terms include. It has therefore declared that they include the right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equally benefit of all laws and proceedings for the security of persons and property. That act, it is true, was passed before the 14th Amendment, but the amendment was adopted to obviate objections to the act or to obviate objections to the legislation of a similar character extending to the protection of the national government over the common right of all citizens of the United States. Accordingly, after its ratification, Congress reenacted the act under the brief that whatever doubts may have previously existed of its validity, they were removed by the amendment. So that's he's talking about a little piece of law history there with the Civil Rights Act, because it was actually I think it went. I would have to go back and be sure, but they passed the 13th Amendment, then the Civil Rights Act, then they repealed the Civil Rights Act, then they passed the 14th Amendment again, then they brought back the Civil Rights Act. It's a very the Reconstruction era was crazy. Anyways, that's not what we're here to talk about. Justice Field goes on to reiterate privileges and immunities, then he finally hits his point of the unlawful employment. The privileges and immunities designated are those which are of right belonging to the citizens of all free governments. Clearly among those must be placed the right to pursue a lawful employment in a lawful manner without other restraints than such as equally affected all persons. In this portion of Justice Field's dissent, he reiterates all the points previously touched upon and giving a direct refutation, really touching on a lot of the same points as we have previously gone through thoroughly. He does make a few very interesting points, though, as he states in the cases of Paul v. Virginia. Quote, but the court answered that corporations were not citizens within the meaning of this clause. That the term citizens, as they're used, applied only to natural persons, members of the body politic owing allegiance to the states, not to artificial persons created by the act of the legislature and possessing only the attributes which the legislature had prescribed. This is very different now. That's it's so fundamentally different that United States citizens are artificial people. So anyways, if you want to read more about that he goes into it. He makes the further distinction between corporations and natural person. Justice Field considered he considers basically stating that Justice Miller's point on Paul v. Virginia is moot. The whole purport of the discussion was that citizens of the state do not carry with them into the states any special privileges or immunities conferred by the laws of their states, of the corporate or other characteristic. That decision has no pertinence to the question involved in this case. So he's stating that Paul v. Virginia, that it has to do with, I'm pretty sure this case has to do with, it's between like conferred on laws of their state as of a corporate or other character. The decision has, yeah, so it's, he's talking about it's a completely different character. It's talking, he's stating Paul v. Virginia is talking about corporations. Yeah, it was between states. That's what it was. He's saying there's no, the whole case was about corporations carrying rights between states, and this is about a case of the Louisiana legislature creating a monopoly. It's a complete non-equivalence. There's no point there. What the clause in question did for the protection of the citizens of the states against hostile and discriminating legislation of the states, the 14th Amendment does for the protection of every citizen of the United States against hostile and discriminating legislation against him in favor of others, whenever they reside in the same state or different states, if under the 4th article of the Constitution equality of privileges and immunities is secured between citizens of different states, under the 14th Amendment, the same equality is secured between citizens of the United States. He goes on to further expound on this point, stating that by virtue, Article 4, previous to the passage of Amendment 14, no state could discriminate against a citizen of another state by way of monopoly or of any other means of abridgment of rights. If this were not so, it would be in the power of the state to exclude at any time the citizens of another state. What the clause in question does for the protection of citizens of the state against the creation of monopolies in favor of citizens of other states, the 14th Amendment does for the protection of every citizen of the United States against the creation of any monopoly whatever. The privileges and immunities of the citizens of the United States, of every one of them, is secured against the abridgment in any form by any state. The 14th Amendment places them under the guardianship of the national authority. All monopolies in any known trade or manufacture are an invasion of these privileges, for they encroach upon the liberty of citizens to acquire property and pursue happiness, and where held void at common law in the great cases of monopolies decided during the reign of Queen Elizabeth. The 14th Amendment places them, so he's saying that the 4th article in the Constitution was for the individual states. That was protection between the individual states of state citizens. And the 14th Amendment places them under the guardianship of the national authority. So if you claim you're a United States citizen, you have, and Justice Field is of the opinion that that's what he's stating here, is he fundamentally disagrees with Justice Miller on all of his points, and he says you're taking such a narrow approach to what the privileges and immunities of the United States, newly created United States citizens that basically, what was the whole point? And here he hits another great point on the monopoly. The exclusive privileges of supplying such yards, buildings, and other conveniences for the prosecution of this business in a large district of country, granted by the Act of Louisiana to 17 persons, is as much a monopoly as though the Act had granted the company the exclusive privileges of buying and selling animals themselves. It equally restrains the butchers in the freedom and liberty they previously had, and hinders them in their lawful trade. So they've been hindered. What they could previously do, they cannot do now. Oh, and this is a great point. I'm not going to read this verbatim. This is a great little point. He's stating in the statute of 21st James 1, which is an English statute. That's why I don't have it linked here. If it's English law, I'm not going to get too much into it now. I'm focusing a lot on American law. But he's stating in 21st James I, out of the cases of monopolies, is what this statute comes from. It outlaws monopolies at common law. Okay, so before the United States was even a country, monopolies were outlawed at the common law, and he's also stating in here that the common law is the jurisprudence that the Pilgrims brought with them when they came over here from England. So, by proxy, no matter which way you slice and dice this up, constitutional, not constitutional, by constitutional amendment, by statute, by whatever, he says it doesn't matter. Before any of this laid down, monopolies, by the laws we adopted over from England, were void at common law, so the monopoly now is void at common law. He said that it basically, and I think he makes a great argument. Justice Field, you should really read this whole opinion by yourself. His dissenting opinion. He lays into Miller and refutes every one of his points. His justices were really upset about this determination. And here he's actually just further expounding on his point that, you know, the common law was brought over here. It's her the civil laws. Since then, the existence in the states of the civil law as the basis of her jurisprudence, freedom and pursuit has been always recognized as the common right of her citizens. So right there, he's stating that the common law was brought over here by England, and monopolies were already outlawed. What are we doing here? Okay, and we finally made it to the end of Justice Field's argument here, and he ends in pretty solid ground. Stating, obviously, states have the right to legislate regulations in the interest of public health. But, when once prescribed, the pursuit or calling must be free to be followed by every citizen, and not just 17 for the benefit of 17 random persons. And unless adhered to in the legislation of this country, our government will be a republic in name only. Justice Field, if only you knew. And here he shows his utter contempt and disgust. The 14th Amendment, in my judgment, makes it essential to the validity of legislation of every state that this equality of right should be respected. How wildly this equality has been departed from, how entirely rejected and trampled upon by the Act of Louisiana, I have already shown, and it is to me a matter of profound regret that its validity is recognized by a majority of this court, for by it the right of free labor, one of the most sacred and imprescriptible rights of man, is violated. Grants of exclusive privileges, such as made by the act in question, are opposed to the whole theory of government, and it requires no aid from any Bill of Rights to render them void. And so he's saying that we don't even need the Bill of Rights. We don't need acts of legislature. I've already laid it out. This is the wrong decision. You guys are making the wrong decision. You're violating the rights of these men, period. And I agree with Justice Field. Knowing what I know about this case, and knowing what I know now about how the 14th Amendment has been used, I'm going to agree with him. Yeah, I'm just gonna read this footnote into the record because it is just such a great footnote. He's footnoting his one of the most sacred and for the right of free labor, one of the most sacred and imprescriptible rights of man is violated. And I'm gonna read you what he is footnoting here, just verbatim, because it's such an awesome quote. The propriety which every man has in his own labor, as it is the original foundation of all property, so it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder him from employing his strength and dexterity in what manner he thinks proper without injury to his neighbors is a plain violation of this most sacred property. It is a manifest encroachment upon the just liberty both of the workman and of those who might be disposed to employ him, as it hinders the one from working at what he thinks proper, so it hinders the other from employing whom they think proper. And I think that's a great little quote about you owning your labor, and why I'll say it this way, and why nobody has a right to take any amount of your labor. Just when you're doing your paperwork this April, think about this quote. Anyways, moving on. Who's next? All right, let's see what Justice Bradley has to say. Which is fully illustrate my views on the important question. And he agrees with Justice Field in his dissent, and he poses two questions. Well, he says he poses two questions, but he actually poses three. The first question is one of the rights and privileges of the citizen of the United States to pursue such civil employment as he may choose, to adopt such, subject to such reasonable regulations as may be prescribed by law. Secondly, is a monopoly or exclusive right given to one person to the exclusion of all others to keep slaughterhouses in a district or nearly 1,200 square miles for the supply of meat for a large city, a reasonable regulation of the employment which the legislation has a right to impose? Those are the first two questions. The first question. The question now settled by the 14th Amendment itself, that citizenship of the United States is the primary citizenship. So what he's explaining here is that basically the points we've gone over, and Justice Field's opinion is that he's saying that the 14th Amendment now made the United States citizenship superior over the state citizenship, and the right of states to regulate the conduct of citizens is undoubtedly a very broad and extensive one, and not to be lightly restricted, but there are certain fundamental rights which the right to regulate cannot be infringed, the ones we've gone over. And he gets into the Magna Carta. He's quoting out of the Magna Carta here. No free man shall be taken or imprisoned or be diseased of his freehold or liberties or free customs, or be outlawed or exiled or in any otherwise destroyed, nor will we pass upon him or condemn him, but by lawful judgment of his peers, by the law of the land. So due process, basically, is that no free man shall be English Constitution writers expounded this article as rendering life, liberty, and property inviolable except by due process of law. This is the very right which the plaintiffs in error claim in the cause. And he's stating here that the basically the life, liberty, and the pursuit of happiness is life, liberty, and property. And what is he saying here? Because right here, rights of life, liberty, and the pursuit of happiness are equivalent to the rights of life, liberty, and property. These are the fundamental rights which can only be taken away by due process of law, and which can only be interfered with, or the enjoyment of which can only be modified by lawful regulation necessary or proper for the mutual good of all. And then here, Bradley, he pulls the quote from Corfield v. Coryell. I'm not going to go over it. We've been talking about what privileges and immunities are. I think everybody gets it. If you want to read it yourself, you can. Like I said, my individual rights one is going to be over Corfield v. Coryell. So we're going to hear a lot more about privileges and immunities in there. And here he's defining Article 4 of the Constitution, it is pertinent to observe that both the clause of the Constitution referred to and Justice Washington in his comment on it speak of the privileges and immunities of citizens in the states, not of citizens of a state. It is the privileges and immunities of citizens, that is, of citizens as such, that are to be accorded to citizens of other states when they are found in any state, or, as Justice Washington says, privileges and immunities which are in their nature fundamental, which belong to the right and citizens of free government. But we're not bound to resort to implications or to the constitutional history of England to find an authoritative declaration of some of the most important privileges and immunities of citizens of the United States. It is the Constitution itself. The Constitution, as it stood prior to the recent amendment, specifies in terms only a few of the personal privileges and immunities of the states, but they are comprehensive in their character. The states were merely prohibited from passing bills of attainder, ex post facto laws impairing the obligation of contracts, and perhaps one or two more. But others of the greatest consequence were enumerated. Although they were secured in expressing terms from invasion by the federal government, such as the right of habeas corpus, the right of trial by jury, of free exercise of religious worship, the right of free speech and free press, the right peaceably to assemble for the discussion of public measures, the right to secure against unreasonable searches and seizures, and the right of not being deprived of life, liberty, and property without due process of law. These are specified in the original Constitution or in the early amendment of it as among the privileges and immunities of citizens of the United States, or what is still stronger for the force of the argument, the right of all persons, whether citizens or not. So he's stating in the Constitution, it doesn't matter whether you're a citizen or not. It's enumerating, if you're here, you have these certain inalienable rights, as they stated it. Even if the Constitution were silent on the fundamental privileges and immunities of citizens, it was not necessary to say in words that the citizens of the United States should have an exercise of all privileges of citizens. The privilege of buying, selling, and enjoying property, the privileges of engaging in any lawful employment for a livelihood, the privileges of resorting to the laws for redress for injuries, and the like. The very citizenship conferred these privileges. If they do not possess them, in these privileges, they would enjoy whether they were citizens of any state or not. Inhabitants of the federal territories and new citizens made such by annexation of territories or naturalization, though without any status as citizens of a state, could nevertheless, as citizens of the United States, lay claim to every one of the privileges and immunities which have been enumerated, and among these none more essential and fundamental than the right to follow such professions or employment as such may choose, subject only to uniform regulation equally applicable to all. So you can't create a monopoly. The next question to be determined in the case is a monopoly or exclusive right given to one person or corporation to the exclusion of all others to keep slaughterhouses in a district or nearly 1,200 miles for the supply of meat for a great city, a reasonable regulation or employment of which the legislature has a right to impose. Okay. And he explains here, the keeping of a slaughterhouse is a part keeping a slaughterhouse is a part of the incidental to the trade of the butcher, one of the ordinary occupations of human life, to compel a butcher, or rather all butchers of a large city and an extensive district, to slaughter their cattle in another person's slaughterhouse and pay him a toll, therefore is such a restriction upon the trade as materially to interfere with its prosecution. It is onerous, unreasonable, arbitrary, and unjust. It has none of the qualities of a police regulation. If it were really a police regulation, it would undoubtedly be within the power of the legislature. So, yeah, you get it. And then he, like I said before, he he states he only has 2 questions, but he actually has 3 questions. Lastly, can the federal court administer relief to citizens of the United States whose privileges and immunities have been abridged by the state? Or this I entertain no doubt. Prior to the 14th Amendment, this could not be done except in a few instances for the want of requisite authority. So, did the 14th Amendment give United States citizens the right to find relief in the federal courts? And Justice Bradley is stating, yes, of course they did, admitting, therefore, that formally the states were not prohibited from infringing any of the fundamental privileges and immunities of citizens of the United States, except in a few specific cases that cannot be said now since the adoption of the 14th Amendment. In my judgment, it was the intention of the people of this country in adopting that amendment to provide national security against violation of the states of the fundamental rights of the citizens. If my views are correct with regard to what the privileges and immunities of citizens, it follows conclusively that any law which establishes a sheer monopoly depriving a large class of citizens of the privileges of pursuing a lawful employment does abridge the privileges of the citizens. The amendment also prohibits any state from depriving any person of life, liberty, or property without due process of law. And in my view, a law which prohibits a large class of citizens from adopting a lawful employment or from following a lawful employment previously adopted does deprive them of liberty as well as property. Without due process of law, their right of choice is a portion of their liberty. Their occupation is their property. Such a law also deprives those citizens of the equal protection of the law, contrary to the last clause of the section. Contrary meaning the opposite of. Okay. Moving on, it is futile to argue that none but the persons of the African race are intended to be benefited from the amendment. They may have been the primary cause of the amendment, but it is language in general embracing all citizens, and I think it was purposely so expressed. I would agree with you. And just ending out Justice Bradley's opinion here, I think it's probably pretty important to read this verbatim because especially this first little paragraph here at least, because it's pretty important. But great fears are expressed that this construction of the amendment will lead to enactment by Congress interfering with the internal affairs of the state and establishing therein civil and criminal codes of law for government of the citizens, and thus abolishing the state governments in everything but name, or else that it will lead to the federal courts to draw to their cognizance the supervision of the state tribunals on every subject of judicial inquiry, on the plea of ascertaining whether the privileges and immunities of a citizen have not been abridged. In my judgment, no such particular inconveniences would arise. Very little, if any, legislation on the part of Congress would be required to carry the amendment into effect. Like the prohibition against passing a law impairing the obligations of contract, it would execute itself. The point would be regularly raised in a suit of law and settled by final reference to the federal court, as the privileges and immunities prosecuted are only those fundamental ones which belong to every citizen. They would soon become so far defined as to cause but a slight accumulation of business in the federal courts. Besides, the recognized existence of the law would prevent its frequent violation, but even if the business of the national court should be increased, Congress could easily supply the remedy by increasing their number and efficiency. The great question is, what is the true construction of the amendment? When once we find that, we shall find the meaning of giving it effect. The argument from the inconvenience ought not to have a very controlling influence in questioning of this sort. The national will and national interest are of far greater importance. In my opinion, the judgment of the Supreme Court of Louisiana ought to be reversed. Great little way to end your argument there, Bradley. And so, which will bring us to the final argument in the case. Alright guys, we have finally made it to the end of the case, the third of the three dissenting opinions, and actually, wait all this time to get to. This is my favorite part of the case because I think Justice Swain is just so concise in the way he puts everything. And this he's going through a little in the beginning of his opinion here. He starts going through a little law history. The first 11 amendments to the Constitution were intended to check the limitation upon the government which that instrument called into its existence. They had their origin and spirit in the jealousy and part of the states which existed within the Constitution, which existed when the Constitution was adopted. The first 10 were proposed in 1789 by the first Congress at its first session after organization of the government. The 11th was proposed in 1794, and the 12th in 1803. The one last mentioned regulates the mode of electing the president and vice president. It neither increases nor diminishes the power of the general government, and may be said, in that respect, to occupy neutral ground. No further amendments were made until 1865. A period of more than 60 years. The 13th Amendment was proposed by Congress on the 1st of February 1865, the 14th on the 16th of June 1866, and the 15th on the 27th of February 1869. These amendments are a new departure and mark an important epoch in the constitutional history of the country. They trench directly upon the power of the states and deeply affect those bodies. They are, in this respect, at the opposite pole of the first 11. So he's saying that the first 11 articles of amendment to the Constitution limited the power of the government, of the federal government, and the 14th Amendment to the Constitution did the exact opposite and bolstered the power of the federal government. Fairly construed, these amendments may be said to rise to the dignity of a new Magna Carta. The 13th blotted out slavery and forbade forever its restoration. It struck the fetters from millions of human beings and raised them at once to their sphere of free men. This was an act of grace and justice performed by the nation. Before the war, it could have been done only by the states where the institution existed, acting severally and separately from each other. The power then rested wholly with them. In that way, apparently, such a result could never have occurred. The power of Congress did not extend to the subject except in the territories. So before the Civil War and the passing of the ratification of the 14th Amendment, the federal government had no power to abolish slavery in any of the states, which is that's a hilarious point to bring up, because the Emancipation Proclamation, there's a big problem with that, is the Emancipation Proclamation technically only by law would have only applied to the northern states, because at that time, before the Civil War, the southern states were sovereign beings. So Lincoln really didn't free any slaves by letter of the law. It was a complete color of law action, but that's for another video. Moving on, Justice Swain is just defining the 14th Amendment there, and the 15th Amendment here. Until this amendment was adopted, the subject to which it relates was wholly the jurisdiction of the states. The general government was excluded from participation. So before the 15th Amendment, only the states could decide who voted or not. The first section of the 14th Amendment is alone involved in the consideration of these cases. No searching analysis is necessary to eliminate its meaning. Its language is intelligible and direct. Nothing can be more transparent. Every word employed has an established signification. There is no room for construction. There is nothing to construe. Elaboration may obscure, but cannot make clearer the intent and purpose sought to be carried out, which I think is a great quote by Justice Swinton here. Elaboration may obscure, but cannot make clearer. So, which really, he's sticking it right to the heart of Justice Miller right there, because he's saying, you said all these big fancy words and made all these big justifications in these big elaborations. All those did was obscure. They didn't make anything more clear, because the 14th Amendment is written in a way where it's clear enough already. There's nothing to construe, as he said. I'm just going to read the first part of this pretty much verbatim, because this is Justice Swain's definition of the 14th Amendment. He breaks it into three parts: citizens of the United States and a citizen of the state and of the state are defined. Number 2 is it is declared that no state shall by law abridge the privileges and immunities of citizens of the United States. And number 3, that no state shall deprive any person, whether a citizen or not, of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. A citizen of a state is ipso facto a citizen of the United States. Okay, so what is ipso facto? Ipso facto is a Latin term meaning by the fact itself, by the very fact or act, or for this fact alone, the following, or for this fact alone. That's what ipso facto means. So they are ipso facto a citizen of the United States. No one can be the former without also being the latter. But the latter, by losing his residence in one state without acquiring it in another, ceases for the time to be the former. So meaning if you move without establishing residency in another state, you are not a state citizen for that time, but you are still a United States citizen. The privileges and immunities of a citizen of the United States include, among other things, the fundamental right of life, liberty, and property, and also the rights which pertain to him by reason of his membership of a nation. The citizens of the state has the same fundamental rights as a citizen of the United States, and also certain others, local in their character, arising from his relation to the state, and in addition those which belong to the citizen of the United States, he being in that relation also. There may thus be a double citizenship, and each having some rights peculiar to itself. It is only ever those which belong to the citizen of the United States that the category here in question throws the shield of its protection. All those which belong to the citizens of the states, except to bills of attainder, ex post facto laws, and laws impairing the obligation of contracts, are left to the guardianship of the Bill of Rights, Constitution, and the laws of the state, respectively. Those rights may all be enjoyed in every state by the citizens of every other state by virtue of Clause 2, Section 4, Article 1 of the Constitution of the United States, as it was originally framed. This section does not in any way affect them. Such was not its purpose. In the next category, obviously, ex industria, to prevent as far as may be the possibility of misinterpretation, either as to persons or things, the phrase citizens of the United States and privileges and immunities are dropped, and more simply in comprehensive terms are substituted. The substitutes are any person and life, liberty, and property, and the equal protection of the laws. Life, liberty, and property are forbidden to be taken without due process of law, and equal protection of the laws is guaranteed to all. Life is the gift of God, and the right to preserve it is the most sacred of the rights of man. Liberty is freedom from all restraint, but such as are justly imposed by laws. Beyond that line lies the domain of usurpation and tyranny. Property is everything which has an exchangeable value exchangeable value, and the right of property includes the power to dispose of it according to the will of the owner. Labor is property and as such merits protection. The right to make it available is next in importance to the rights of life and liberty. It lies to a large extent at the foundation of most other forms of property and of all solid individual and national prosperity. Due process of law is the application of the law as it exists in the fair and regular course of administrative procedure. The equal protection of the laws place all upon all footing of legal equality and gives the same protection to all for the preservation of life, liberty, and property in the pursuit of happiness. So he's agreeing with Justice Bradley, or Justice Field, sorry, when he's making a big point about you owning your labor and about your labor being sacred, which I 100% agree with, and nobody has a right to put their hands on your labor. And Justice Swain really he ends it on a really strong note right here, so I'm basically just going to read the rest of his opinion verbatim. These amendments are all consequences of the late Civil War. The prejudices and apprehensions as to the central government which prevailed when the Constitution was adopted were dispelled by the light of experience. The public mind became satisfied that there was less danger of tyranny in the head than of anarchy and tyranny in the members. The provisions of this section are all eminently conservative in their character. They are a bulwark of defense and can never be made an engine of oppression. The language employed is unqualified in its scope. There is no exception in its terms, and there can be properly none in its application. By the language citizen of the United States was meant all such citizens, and by any person was meant all persons within the jurisdiction of the state. No distinction is intimated on account of race or color. This court has no authority to interpolate a limitation that is neither expressed nor implied. Our duty is to exercise the law, not make it. Which, great point there, Justice Swain, because, man, you would be, you gotta be rolling over in your grave right now. Our duty is to execute the law, not make it, not to make it. The protection provided was not intended to be confined to those of any particular race or class, but to embrace equally all races, classes, and conditions of men. It is objected that the power conferred is novel and large. The answer is that the novelty was known and the measure deliberately adopted. The power is beneficent in its nature and cannot be abused. It is such as should exist in every well-ordered system of polity. Where could it be more appropriately lodged than in the hands to which it is confined? It is necessary to enable the government of the nation to secure to everyone within its jurisdictions the rights and privileges enumerated, which according to the plainest consideration of the reasons and justice and the fundamental principles of the social compact, all are entitled to enjoy. Without such authority, any government claiming to be national is glaringly defective. The construction adopted by the majority of my brethren is much too narrow. It defeats by a limitation not anticipated the intent of those by whom the instrument was framed, and of those by whom it was adopted. To the extent of the limitation, it turns, as it were, what was meant for bread into a stone. By the Constitution, as it stood before the war, ample protection was given against oppression by the Union, but little was given against wrong and oppression by the state. That want was intended to be supplied by this amendment. Against the former, the court has been called upon more than once to interpose. An authority of the same amplitude was intended to be conferred as to the latter. But this arm of our jurisdiction is in these stricken down by the judgment just given. Nowhere than Nowhere, then, in this court ought the will of the nation to be more liberally construed or more cordially executed. The determination of the majority seems to be to lie far in the other direction. And this is the last line of this entire case. I earnestly hope that the consequences to follow may prove less serious and far-reaching than the majority fear they will be. Well, sorry, Justice Swain. They're probably far beyond what your wildest imagination could have even imagined. Could have even brewed up what you were thinking back then. You have got to be rolling over in your grave right now. This opinion has got me really interested in Justice Swain. I'm actually going to build a database of his opinions and start reading about him more, because he seems like a really interesting character. He puts it right out there and he just throws it right in the face. He's like, I see what you're doing. All of the dissenting opinions were basically like, we see what you're doing and you're just doing it in plain sight. Hey, hello everybody. But anyways, let's wrap this thing up now, because I'm sure you guys are ready to get going. But if you're here this long, thank you for sticking with me, and I appreciate you being here. And don't forget to visit the Thought Crime Dojo, and there'll be a button that you can press right in the educational package to get you the Thought Crime Dojo. It gets you to a bunch of different resources. I got a law library in there where I'm dropping more new Supreme Court decisions every day. All the books, law journals, everything that I gather, I'm going to be throwing in there. And obviously, the educational package will be available to you also. But I did just want to wrap it up and hit just a real quick summation of this case and what we learned. Basically, there was a 25-year exclusive privilege granted to 17 people to build a stockhouse landing that all other people butchering animals had to take it to, and by a vote of 5-4, the court upheld the law as a valid exercise of the Louisiana police power to protect the health. So by a 5-4 vote, they upheld that Louisiana could grant a monopoly in this particular case. The court rejected all federal constitutional challenges and affirmed the Louisiana Supreme Court. In Justice Miller's defense, right here, he says that he would be infringing on states' rights if he did this, because we've beat the privileges and immunities with a dead horse. And due process, the law did not deprive the butchers of property. Without the due process, they could still practice their trade, albeit at a designated place and with a fee, of course. We just went through the dissenting opinions, so you guys are familiar with those. And the bottom line is the court upheld the slaughterhouse monopoly as a valid health regulation. It sharply limited the federal Privileges and Immunities Clause to narrow national rights, a move that shaped constitutional law for generations by channeling most rights claims through due process and equal protection instead. So, that's it, guys. Thank you for joining me. Don't forget to visit the website, truelifeproduction.com. Check out all the resources there. You can watch all the shows there. That'll get you to the Thought Crime Dojo. That'll get you to my other show, All Aboard. Check everything out. I really appreciate you guys being with me, and never forget to seek truth and honor the Creator above all, and let that be the whole of the law.
I have had men watching you for a long time, and I am convinced that you've used the funds of the banks to speculate in the breadstuffs of the country. When you won, you divided the profits amongst you, and when you lost, you charged it to the bank. You tell me that if I take the deposits from the bank and annul the charter, I should ruin 10,000 families. That may be true, gentlemen, but that is your sin. Should I let you go on, you will ruin 50,000 families, and that would be my sin. You are a den of vipers and thieves. I've determined to rout you out, and by the eternal God, I will rout you out. slaughterhouse. End quote. Andrew Jackson. But it's something that you need to understand, that all of these wars and assassinations that we're told are crazed lone nut assassins, or weapons of mass destruction, or bringing democracy, all of them track back to the private central bankers. And the more you study this, the more you will realize all the wars are wars for the bankers. And I know a lot of people are going to have difficulty comprehending this. Just how many of these wars we have fought as a nation were fought for no other purpose than to force private central banks onto nations that did not want them.
That is your sin.
So we're going to have a few examples so you understand why at this particular time in history the United States government is mired in so many wars against so many foreign nations. Now, going back to the beginning, the United States fought the American Revolution primarily over King George III's Currency Act, which forced the colonists to abandon their own government-issued currencies and conduct business only using printed banknotes borrowed at interest from the Bank of England. So the revolution was over, the United States was born, but the private bankers are nothing if not dedicated to their
schemes to acquire other people's wealth.
Now, just 1 year after Mayor Amschel Rothschild had uttered his infamous, "Let me issue and control the nation's money, and I care not who makes the laws," private bankers succeeded in setting up a new private central bank called the First Bank of the United States. Now, this First Bank of the United States was founded in 1791, and by the end of its 20-year charter, the First Bank of the United States had almost ruined the nation's economy while enriching the bank's owners. Financed by the Rothschild-controlled Bank of England, Britain then launched the War of 1812 to recolonize the United States and force them back into the slavery of the Bank of England. Even though the United States won the War of 1812, Congress was forced to grant a new charter for yet another private bank, issuing the public currency as loans at interest, the Second Bank of the United States. Private central bankers. Private central bankers. And in 1832, Andrew Jackson successfully campaigned for his second term as president under the slogan, "Jackson and no bank." True to his word, Jackson succeeded in blocking the renewal of the charter for the Second Bank of the United States of America. So it should probably be no surprise that the financial dimension of the Civil War are not well known to the average American. It's portrayed in our history books and our popular media as an internal dispute over slavery, but in fact it was a war with global implications. When the Confederacy seceded from the United States, the bankers once again saw the opportunity for a rich harvest of debt and offered to fund Lincoln's efforts to bring the South back into the Union at 30% interest. Lincoln remarked that he would not free the black man by enslaving the white man to the bankers, and using his authority as president, issued a new government currency, the greenback. So goaded by the private bankers, much of Europe supported the Confederacy against the Union, with the expectation that victory over Lincoln would mean the end of the greenback. Following Lincoln's assassination, the greenbacks were pulled from circulation, and the American people forced to go back to an economy based on banknotes borrowed at interest from the private bankers. So finally, in 1913, the private central bankers of Europe, and particularly the Rothschilds of Great Britain, the Warbirds of Germany, met with their American financial collaborators on Jekyll Island, Georgia, to form a new banking cartel with the express purpose of forming the Third Bank of the United States, with the aim of placing complete control of the United States money supply once again under the control of private bankers. Owing to hostility over the previous banks of the United States, the name of this Third Bank was changed to the Federal Reserve, in order to grant the new bank a quasi-governmental image. But in fact, it is a privately owned bank. It's no more federal than Federal Express. In fact, last year, the Federal Reserve successfully rebuffed a Freedom of Information lawsuit by Bloomberg News on the grounds that as a private banking corporation, and not actually a part of the U.S. government, the Freedom of Information Act did not apply to the operators of the Federal Reserve.
The Freedom of Information Act did not apply to the operators
private
of the Federal
central
Reserve.
bankers, private central 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 bankers,